Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. I'm posing the question based on a couple of filings from this past week as to whether Judge Stephen J. Hippler may have provided a clue as to how he may be leaning with respect to the state's motion in Limine filed on the 21st of February 2025, addressing the alibi defense. Now, just by way of background, no criminal defendant is ever required to give testimony on his own behalf, to put up a defense even, because the standard is that a defendant in a criminal case is presumed innocent at all stages of the proceeding until or unless he is either or she is either adjudicated guilty at trial or pleads guilty. There's a Fifth Amendment privilege against self-incrimination that also is invoked here, but many times defendants will willingly put on a defense to whatever criminal charges they're being faced with. Here, Mr. Kohberger has 5 first-degree felonies that he was indicted on, that he will stand trial for in this capital case this summer. An alibi defense is something that, when executed properly, can be very powerful. It basically says, I could not have committed these crimes I'm charged with because I was not there. I was not at this bank that you're claiming, government, I robbed, because at that time I was at work 100 miles away. Or I could not have committed this unaliving crime that you're charging me with because at that time I was on an airplane flying to Mexico for a vacation. And key to an alibi defense is corroborating evidence. In other words, just can't say, I was there. It must be substantiated with evidence. And usually what that means is by either the defendant taking the stand and saying that and producing other things, such as receipts showing he was on a plane or she was on a plane, or pay stubs showing he or she was at work. A lot of times it'll be the defendant's boss, manager, supervisor, who will be called into court to testify, yes, indeed, the defendant here, my employee, was at work at that time. Or if the person was flying, maybe someone who was accompanying him or her on that trip will come into court, along with the airline tickets and other documentation, passport being stamped, things like that. What is happening here is that Mr. Kohberger did raise the defense that he was driving elsewhere at the time that the crimes happened in 1122 King Road, and so therefore he could not have committed these crimes. But he's not so far stated who would be able to get on the stand and testify who has first-hand knowledge, meaning if he's driving alone, him, or if he stopped somewhere to get gasoline, he stopped to get a meal somewhere, people from the gas station, people from the restaurant, or if he was not driving alone, someone who was in the car with him. What he's looking to do through a partial corroboration is to have a proposed expert witness get on the stand and corroborate this alibi defense through technology. In any event, after the state filed their motion in limine on the 21st, seeking to have, if Mr. Kohberger is going to continue to demand that his alibi defense be acceptable, then he's got to get up and take the stand. So, what has happened here is that the defense has filed a response in opposition to the state's motion in limine, and in addition, they filed defendant's motion for leave to allow witness testimony at the April 9th hearing. What is the April 9th hearing? That is the first day of the two-day hearing schedule for the hearings on the numerous motions in limine, this being one state's motion in limine as to the alibi defense. Leave means seeking permission from the court to do something or not do something. Here they want leave to allow experts to provide testimony. This motion, which followed the court order, so we already know how the court ruled, names the witness as Cy and talks about what Cy would be expected to testify in support of the defendant's position in opposition to what the state's looking to do relative to the alibi defense. And it goes into detail. Now, Judge Hippler, it's a no with a caveat. He says, nope, don't need to have them in the courtroom. Have them ready to go. If there are any questions, we can have them testify, if need be, via virtual technology. The other witness that the defense wanted to present at hearing is David Howe, and you can read about who David Howe is and what his expected testimony would be, starting on page 5 of this motion for leave. Basically, David Howe is an expert in the branding industry, to include Amazon records, data retention, algorithm-driven recommendation systems, cross-platform tracking, user accounts, and buy box system, clickstream tracking systems, and the need for complete data for informed opinions. But the more interesting of the two, in my opinion, is Cy because of the alibi defense. And the defense goes into a lot of detail why this is a capital case, this alibi is important to him, and why it is that Mr. Kohberger should be able to have Cy take the stand. On page 4, he's saying here, Cy has a background with AT&T records and understand records that exist and how they are distributed. He will provide testimony about AT&T timing advanced records. He will testify that the timing advanced records existed through AT&T, and so on and so forth. Then he goes into, on page 5, in rebuttal of state's motion regarding alibi, Mr. Kohberger relies on partial corroboration for his alibi that he was driving alone west and south of Moscow on November 13th, 2022. That is the date of the crimes, ladies and gentlemen. He then says partial corroboration disclosed as required is in the form of AT&T records and mapping the same. The specific focus is on cellular device interaction between cell towers and drive testing data through the last 7 minutes before the phone stopped reporting to the network. We learned about that for the first time, that there was a time when Mr. Kohberger's cell phone stopped reporting to the network in the affidavit of probable cause that was signed by Detective Brett Payne of the Moscow Police Department. You can read it in its entirety. It is item number 1 on the Idaho versus Kohberger court files, dated December 29th, 2022. It directly led to the issuance of the order finding probable cause for Mr. Kohberger's arrest and to his arrest warrant. Both of them were signed by Magistrate Judge Megan E. Marshall, also on the 29th of December 2022, leading to Mr. Kohberger's arrest across the country at his parents' home, Monroe County, Pennsylvania, the early morning hours of the 30th of December 2022. But beyond that, says here, for the first time on March 3rd, 2025, the state disclosed special agent balance, mapped handoffs for the last 7 minutes. Mr. Ray will provide testimony that mapping of those handoffs partially corroborate Mr. Kohberger's alibi and are exculpatory, meaning that this is favorable to him as not being the perpetrator of these crimes that he is charged with. Judge Hippler, as I've said, 1 day later, denied the motion to have leave for both of these witnesses appearing in court, and we can just draw our own conclusions. It appears, in my opinion, that Mr. Kohberger is looking to have an unorthodox way of presenting an alibi defense, and might that not be helpful if Mr. Ray was present in the courtroom so the court could observe his body language, how he comes off asking questions live. He can do those things to some extent, obviously, in a virtual testimony if he's appearing virtually, but it seems to me, in a way, such an important witness to this alibi defense, which has been so hotly contested, such an important witness should be in the courtroom. That's one argument, maybe not, but what are your thoughts and comments on this matter? Do you think that this is any indication, pro or con, regarding how the court might be leaning towards regarding this matter? Let me know, and I want to thank you. I've received such great comments, great support on the channel. I really appreciate it. If you can, please like, subscribe, and comment all of your comments, no matter where you stand. If you feel that the evidence that you've started to see, since things have been a little bit loosened in this case, where so much of it has been under seal, leads you to believe that Mr. Kohberger did not commit these crimes, or alternatively the opposite. If you feel that the state's case is looking stronger, let me know. All of your comments and opinions are welcome and appreciated. This is Kathy. Thank you for joining us here today.